So let's talk about duties to the client with a focus on conflicts of interest, which are clearly part of the family of fiduciary duties that lawyers have to their clients. It comes out of this idea of a duty of loyalty, so the loyalty that we owe to our clients. Before we get too far, let's think about the situations in which the duty might be applied. So just think about how strictly is a fiduciary duty applied? How important is it? So let's start with perhaps the example of a solicitor who claims that they were acting bona fides. So they were acting honestly. Or potentially that the client themselves might have benefited from the breach, that by taking a particular interest in the matter, and even though they might have benefited themselves as lawyers, the client also benefited. Is that a defence? The short answer is clearly not. Boardman and Phipps, which is one of the premier cases in relation to fiduciary duties, will show us that. So what about situations where the work is delegated, say to staff or maybe to some kind of technology, for example? So clearly lawyers have a duty of supervision, and this is one of the reasons why when you work in a law firm, there is so much process about making sure things are well signed off. Because essentially cases like Reed Bannister and others demonstrate that the lawyer owes a fiduciary duty, and as a consequence, to the extent that they delegate to a staff member, or to the extent one would think by extrapolation that they use technology to deliver that service, that they remain responsible for the services that they provide. Okay, so what about situations where the lawyer doesn't charge a fee? So in Sims Craig and in Sims Craig Bell and Bond, sorry, don't you hate it when case names have ands in them because you start to say it ridiculously? But anyway, in Sims and Craig Bell and Bond, a 1991 New Zealand case, Justice Richardson essentially said that the fact that no fees were charged could not absolve a lawyer from a breach of a fiduciary duty, and in doing so called on Morris Fletcher and Cross's bills of costs in relation to that fiduciary duty. Also, what about the question then of commercial reality? Are we in a position that the world has changed? We've got a lot of big firms. Clearly the big firms act for a lot of different people, and those entities, they might actually have fights with each other or do deals with each other. And so as a consequence, the lawyers are acting not only for a client, but also for the other side in matters, even if it's in something unrelated. It's a commercial reality that the big firms are getting bigger, a lawyer's got to make a buck. Surely the fiduciary duty doesn't apply if the commercial reality is such. Short answer, no. Doesn't matter what the commercial realities are. It is very clear that the fiduciary duty to the client comes first. Now, Del Pont is probably the best source for reading about the fiduciary duty and seeing the seriousness of the cases. I have to say, sometimes I look at the cases and I think, oh my God, how on earth is a law firm ever going to make a buck? The fiduciary duties are so strong that it is very difficult to act for anybody who might have any kind of relationship with your client, with an existing client or a previous client. Now, clearly, there are ways around this, and we're going to talk particularly about information barriers. They used to be called Chinese walls back in the olden days. But these, we'll talk about that in some detail in another video. But it is really important to understand that these are very, very strict duties. They come as part of not only the rules, the Australian Solicitors Conduct Rules are where I want you to be looking in the first instance, but they come not only through those rules, but those rules codify many, let's face it, hundreds of years of equitable rules. Now, clearly, sorry, I know I said the words we get around it, and I don't want to give you the wrong impression. But clearly, despite the debate about the profession or business, lawyers at the end of the day are needing to exist in a world that is complex, where there are interrelationships between all sorts of parties. And it is really important to ensure that you understand the rules, understand how strictly they are applied, but also see what steps lawyers have to take to ensure that they can navigate the business of law in ways that mean that they can grow their experience, that they can provide the best advice to their clients, that often means specializing in a particular industry, but as a consequence, lots of entities within that industry that might in fact conflict with each other may actually require advice from the same advisors, and how we as lawyers need to navigate that. So that's going to be a key thing that we are talking about in this particular video. But overall, essentially all of the things that I put up on that slide that you can see next to me are essentially a breach of fiduciary duties, or if they're not a breach of fiduciary duties, depends on how it's phrased, they are not an excuse or a defense to a breach of fiduciary duty. So, key point here, avoiding conflicts of interest and managing the way that we deal with clients to maintain that loyalty and confidence is absolutely key to being a good lawyer. So I keep saying this, that behind the idea of conflict of interest is this idea of the duty of loyalty. So what is the duty of loyalty? It's the duty to avoid a conflict between your personal interest as a lawyer and the interests of a client. So this goes to who you can onboard as a client, as well as the duty of confidentiality that you owe to former clients. So when we're looking at the interests of clients, we need to think about the extent to which we could have concurrent conflicts. And when we're thinking about the duties of confidentiality that we owe to former clients, we call these successive conflicts. So the question becomes, a concurrent conflict is where you are acting for two parties that have conflicting interests. So to the extent where to act fully and to share all of the information and knowledge that you have in relation to a relevant matter with your client, you could only do that by breaching your duties of obligation, your duties of confidentiality and loyalty to another client. That is a concurrent conflict. A successive conflict is a situation where, in order to properly fulfill your duties to a new client, you would need to share all of the information that you have that is relevant to their matter or to their dispute or to the circumstances in relation to which they have sought your legal advice. But in doing so, you would breach your obligation of loyalty or confidentiality to a former client. So duty of loyalty and conflict of interest are really closely related to what we were talking about in week 6, the lawyer's obligations of confidentiality to keep your client's affairs confidential and to preserve legal privilege. And so you'll remember, and I've taken this time the diagram on the slide for those of you who are listening from home. There's a diagram that comes straight out of chapter 4 of Parker and Evans to show that basically all information that is confidential is protected in the lawyer-client relationship, but not all confidential information is privileged, which has that higher order protection. Conflicts of interest are probably the single most difficult issue for practitioners to both understand and deal with in practice. Both Delpont and Parker and Evans have a range of different examples, many of them quite recent, and you'll be seeing these in the news regularly. Again, if I've said it once, I've said it 100 times. Sign yourself up to the free LIV student membership and make sure you can have a look at the LIV journal regularly, and you'll see that conflicts of interest play out in practice regularly as the kinds of ethical issues that are reported in that journal, where the Legal Practice Board and Commissioner are taking action because of breaches of that fiduciary duty. Conflicts are also one of the most, well, having a conflict of interest is one of the ways that you can most easily disappoint and upset a client. Usually that's because a client has placed an enormous amount of trust in your lawyers. There is this information asymmetry, this knowledge asymmetry. They trust you as their lawyer to deal with their most sensitive and secret information. And so if that trust is breached, they need to understand or comprehend how and why you as their lawyer might be prepared to switch sides on them. That's their perception that they get. Confidentiality breaches and conflict of interest breaches are the sort of stuff that legal movies and TV shows are made of. Often, like the case study that I included at the end of week 6, those case studies where that duty of loyalty results in keeping somebody or somebody else being very unfairly treated. They're really unusual and extreme versions of these kind of issues. But just sometimes it's the little things that can be really disappointing, that inadvertent slip when you're talking to somebody about a transaction that they're interested in involved in, and you mention that somebody else has got a better price. Those kind of things can be really damaging to your relationship and your reputation, as well as being a breach of your fiduciary duty as well. And one of the reasons why the law takes these so seriously, because breaches of this fiduciary duty, breaches of the duty of loyalty, also put the profession into disrepute. So when we talk about the duty of loyalty, what are we talking about? So the common law position is that a solicitor's duty of loyalty to a client will survive the end of the retainer. So we'll talk about retainers next week. Retainer is just a fancy word for the contractual relationship that the client and solicitor have, or client and lawyer have. So at common law, the position is that if you have a duty of loyalty to a client, you have finished doing legal work for them, so there's no longer any contractual relationship. Both parties have satisfied their contractual relationship. The duty of loyalty that you have, including that duty to maintain the confidentiality of their information, continues on after that period of time. And as a consequence, you can be prevented from acting against the interests of a former client in the same or in a related matter. So the key case here is Spin Code. It's a 2001 case, so it's quite old. There's been lots written about Spin Code. And again, I would suggest that you make sure that you have a good look at the way that Delpont deals with Spin Code in particular. This case has been followed and applied in a series of Victorian Supreme Court decisions. And while it hasn't received wholesale endorsement in other jurisdictions, it's absolutely the law in Victoria. And so, the LIV says that Victorian lawyers would be wise to follow the advice in it. And as pending Victorian lawyers, I'm going to leave it with you at that. It's also some of the language, and I've used it myself. I talk about potential conflicts of interest, and that's kind of loose of me to do that. And I'm going to apologize actually, because when I'm using the language potential conflict of interest, I am really asking myself, is there the potential for a conflict of interest to exist? It's conflicts of interest either exist or they don't exist. Sometimes we can put ourselves into situations where the potential might arise, so where there is potential there, but we need to, on a case-by-case basis, examine whether there's a conflict or not. And in some situations, there is more potential for a conflict to exist than otherwise. So I guess, so in the words here of Justice Cummins, he refers to potential conflict as being tautologous. And he said, and the words are on the slide here, what bedevils the prohibition of conflict of interest is a confusion of purposes. The purpose of prohibition of conflicts is not to remedy an offence or a failure. The purpose is to prevent an offence, to prevent a failure. Prohibition of conflict operates upstream of the offence. It's preventative. It's a prophylactic. So in other words, it's not too much to say you can't be a little bit pregnant. You're either pregnant or you're not. You either have a conflict or you do not. And the purpose of conflicts of interest and the prohibition against them is to prevent a breach of the fiduciary duty, to prevent the breach of your duty of loyalty. So it is no answer to a breach of conflict to say that no harm in fact occurred, that the client wasn't harmed. If a harm, a loss, a failure, an offence occurred, you would be dealt with for a consequential matter. Prohibition of a conflict is an antecedent matter, and that's why he calls it tautologous. Well worth looking at that language. One of the key places where conflicts arise are when there is a financial difference between your duty to your client and the interest that you have in a practitioner as a practitioner financially. So these are really, really clear. And so this and is something that we need to explore at the highest order, that we cannot put our own desire for financial gain ahead of our client's interest. And that's why we need to be very careful to ensure that we do not use the information that is given to us by a client in relation to investments, in relation to our acquisition or disposal of assets, or so purchasing things from clients, purchasing things based on the advice that clients give us. And I'll get into that in a little bit more detail as we move ahead. But I just want to highlight it as the conflict between your interests as a practitioner and the interests of your client. The financial ones are the ones that really, really stand out. But they're not only financial. The other thing that I want to look at is this kind of mud map that I've got on the slide. And so for those of you who are playing along at home, make sure you get the slides and you will see, I think it's slide 10 in my pack. The heading is Practitioner and Client Conflict. You'll see that there are 4 key ways in which practitioner-client conflicts can arise. And we will look at most of these in some detail, but again, I would advise you to make sure that you are really clear on each of them for the purposes of the exams going forward. So basically the primary issues come out of these. Is your advice independent? Are you engaging in some kind of personal transaction where there is a conflict between the client's interest and your own? Are you engaging in some sort of intimate relationship with the client that is inappropriate and could cloud your judgment? And ultimately, we'll deal with this one in a little bit more detail. Are you charging them the right amount of money? And then we've got the secondary issues or secondary problems that fall out of these things. So things like secret profits or commissions, borrowing from clients, lending to them, purchasing property from them, and then ultimately the issue that comes up with you being a witness for or being called to be a witness against your client and what that means. And this is where it overlaps in particular with this idea or this concept of legal professional privilege. So what are the relevant rules here? Now, we spoke about Rule 9 in some detail last week, and I'm not planning to go through it in any detail. Make sure you have a look at that and you've thought about what it means. But there are a couple of others that sort of fit into that. So Rule 9 is the rule around confidentiality. And it basically codifies the common law and the equity position about we're providing a strict liability or obligation not to disclose any information that's confidential to the client and acquired by the solicitor during the engagement as solicitor. But there are other relevant provisions that you do need to be aware of, and you need to think about in the way that you deal with your clients and how these also impact on our duty to them. Rule 7 in particular deals with the way that we communicate our advice, the requirement for advice to be clear and timely, and also to set out alternatives in a meaningful way when that is required. And also Rule 8 can really be relevant here, where we have a duty, and it's very tightly written. It's very clear, a duty to follow the instructions that our client give us. So moving on from there, Rule 10 becomes really important and what we're really going to focus on here. So Rule 10 replaced the old PCPR Rule 4, so when the Uniform Law came in. And Rule 10 is concerned with the conflict between the duty of confidentiality that's owed to a former client and a solicitor's duty to use all of their knowledge and skill for the benefit of a new client. So this is absolutely the successive conflict situation. So where a lawyer, and clearly this comes from the Australian Solicitor Conduct Rules, so it's going to focus on, this particular rule will focus on solicitors, but it's a codification of common law position really. So if a lawyer, a solicitor is in possession of confidential information that belonged to a former client or it obtained during acting for a former client, and that information is relevant and material to another client's matter, and detrimental to the interests of the first client if it were to be disclosed, then you cannot act for the new client in that matter unless you meet either of two permissive exceptions. Number one, where the former client is given informed written consent to the solicitor or the law practice, or an effective information barrier has been established. So in the next video, I'm going to talk about effective information barriers. Informed consent is where we're going to spend our time initially, and really understanding, well, what does it mean for there to be informed consent? So the LIV has provided some guidance to lawyers at the time that the changes here, which were those permissive exceptions, came in. Some of it is really helpful, some of it less so. So one of the things that is really difficult here is the term confidential information isn't defined by the conduct rules, which means that we need to go back to the common law for guidance on what that means. On the slide here, I've got a list of different things that different places that you can look to understand what that means and what informed consent involves. So there's a lot of reading around this, and ultimately we need to take a common sense approach to this. If information is imparted to you in confidence, it is imparted to you under your retainer, which is likely to have a contractual obligation of confidentiality, or it is imparted to you in the context of you providing legal advice so that you can, whether it's in a litigation context or otherwise, so that you can provide the the best advice that you can because you're fully informed. If it's information that is not otherwise disclosed to the public, then it is likely to be confidential information. It is prudent to take the view that information is confidential unless your client believes otherwise and provides you with that informed and written consent. Getting informed consent can be really difficult because in order to inform your client how a successive client might wish to transact, or how you're advising that successive client, in fact could be a potential breach of your duties of loyalty to that new client. So it can be really tricky, really difficult indeed, and at each occasion requires some really sensitive consideration of what is involved. The slide there will give you a couple of cases. I can see one of them is rubbed out, so I am going to slightly change the formatting of that slide so that people can see it when I share them. So where other places where this duty of loyalty comes out is where you might be transacting with a client outside your professional lawyer-client relationship. So Harvey's case is the most important of the authorities here, and I'll talk about that in a little bit more detail shortly. But Justice Brennan said in that it was actually Justice Street who said in that case, relying on the judgment of Justice Brennan in Leary and the Federal Commissioner of Taxation, that there is a presumption that non-professional transactions between a practitioner, so a lawyer, and their client should not be upheld unless the practitioner can establish that it was freely entered into by the client and without any influence on the practitioner's part. The reason for the presumption is that the practitioner will be personally interested in a transaction with their client, and they cannot give the disinterested advice that is expected of a fiduciary otherwise. So this means the practitioner must only deal with a client in a non-professional sense, so in some commercial sense that doesn't involve legal advice, if they have fully and candidly disclosed their interests and taken steps to ensure that the client has given fully informed consent. So again, Justice Kirby, or President Kirby as he was at the time, in O'Reilly, is pretty helpful in that regard. So have a look at Fabricius as well. And again, all of these cases are discussed in some detail in Delpont. So, and rules. There are also rules here, rules 12.4.3 and 12.4.4 are quite specific about commercial transactions with clients. Okay, so what about borrowing money from clients? Can you do that? Well, will not surprise you to see that Rule 12.3 prohibits a solicitor from borrowing any money or assisting an associate to borrow money from a client of the solicitor or of the client of the solicitor's law practice, or a former client of the solicitor who has indicated a continuing reliance upon the advice of the solicitor. Unless, so we do have a carve out, the client is an authorised deposit-taking institution, in other words, a bank, a trustee company, in other words, it is legally the client but is not the beneficial owner of the assets that are being borrowed from, or the responsible entity of a managed investment scheme, or a custodian of some scheme like that, or an associate of the solicitor, and the solicitor is able to discharge the onus of proving that they have full written disclosure that have been made to the client and the client's interests are protected in the circumstances, whether by independent legal representation or otherwise. The employer of the solicitor is another carve out actually too. So solicitors can borrow money from the firms that they act for. So in order to think about this, what's important here is that a client needs to know both the risks attached to the loan and the advantage that could flow through to the practitioner. Key case here is Law Society of New South Wales and Moulton, a 1981 case, again discussed in Delpont. Harvey, once again, is the leading case on practitioner-client dealings. And in that case, some of Harvey's clients lent money to 3 companies, of which Harvey was a director and a shareholder. And Chief Justice Street found at the time that Harvey had used the client's loan as risk capital in some speculative land ventures and recklessly disregarded the need to protect the client's interests by failing to provide adequate security. So there was a clear conflict between Harvey's personal interests, the interest that he had in those companies, both as a director and a shareholder, and the advice that he gave to the client. Chief Justice Street said that a solicitor who acts as a loan broker should be precluded by the solicitor-client relationship from recommending that clients lend money for a venture in which the solicitor has an interest. He was found guilty of professional misconduct and ultimately was struck off the roll. So I think this is a slide where I was going to talk about Harvey's case. So anyway, there's a lovely little pretty picture of a piggy bank on this slide with an umbrella over it, really trying to show you that if we're separating out, if we're going to protect a client's funds, we protect them as well from our client. So in Harvey's case, Justice Street identified the following elements as comprising the duty that a lawyer has to act in good faith. So the lawyer must not permit their own interest to override those of the client. The nature of the lawyer's the nature of the lawyer's interest must be fully disclosed to the client. So not just I'm a director, but what do I stand to gain from this? There must be full disclosure. If a client of interest can be avoided, then it needs to be avoided. When a conflict of interest remains, then the lawyer should advise the client to obtain independent legal advice or consider withdrawing from the transaction altogether. And the lawyer's interests have the potential to abuse the client's position. So it's taken as a very serious matter. So let's think then about what that means. So we've talked about borrowing from clients. What about lending to clients? President Kirby, as he was then, said in O'Reilly that as a minimum, a practitioner needs to fully and candidly disclose the interest and advise and facilitate the provision of independent advice to the client, as well as advise on and facilitate access to alternative sources of funds. So practitioners should never act as a surety or a guarantor for a client. And similar principles apply where a practitioner proposes to purchase a property belonging to a client. The practitioner needs to ensure that the client seeks independent expert advice and must also disclose the interest the practitioner is inquiring if the client or the vendor is unaware of it. And I mentioned this case before, Bannister, a barrister and a solicitor, 1979 case in relation to that. So Rule 17.4 is the codification of the rule in a barrister and a solicitor. Similarly, in relation to buying property from a client, the same principles apply. So practitioner needs to ensure that the client seeks independent expert advice and must also disclose the interest of the practitioner, particularly if the client or the vendor is unaware of it. So what about former clients? So if there is a continuing practitioner-client relationship, even though the practitioner is not acting for the client in that particular transaction, there is a prima facie duty of disclosure and a prima facie duty to advise the client to seek independent advice. The question about the fiduciary relationship, whether the incidents of the fiduciary relationship subsist in a particular case, is really one of degree. So formal termination of the relationship, although important as a consideration, may not be conclusive and may not excuse the duty to disclose because of the importance of maintaining the public perception of the integrity of the profession. And because that duty of loyalty goes beyond the contractual term of the retainers. So practitioners are advised to err on the side of caution in dealings with former clients. So at the most extreme, decline to get involved at all, or any involvement would be subject to the informed consent of that former client, which sometimes the new client will not want to let you talk to the former client about what their intentions are, which means that you can do nothing other than decline to get involved. Okay, what about intimate relationships with clients? So beyond the commercial relationship, but intimate relationships, family or romantic relationships. Ultimately, these will usually involve a conflict of interest because your ability to be independent and professional, to use your professional judgment, can be affected by the personal interest or perceived to be affected. A key case in this regard is the Crown and Szabo. So in this particular case, a defence counsel was in an interrupted, shall we call it, phase of a relationship that they had, with a Crown prosecutor on the same case. The defendant ultimately succeeded in an appeal against the conviction on the basis that their lawyer had a conflict of interest because he could show that he may not have received independent legal advice, that his lawyer may have, their judgment might have been impacted by that interrupted relationship. So ultimately there was the potential for a reasonable suspicion of a miscarriage of justice, and that perception was enough to mean that the lawyer was shown to have breached their duty. In Legal Practitioners Conduct Board and Morel, a 2004 South Australian case, a criminal law practitioner who suffered from depression and possible borderline personality disorder ultimately was struck off after forming a series of personal relationships with their clients, including prisoners, over many years. The relationships were found to have had adversely impacted on her representation of at least one of those clients because they allowed her client to make recorded admissions of serious criminal conduct during a telephone conversation where the client didn't realise that the telephone conversation was being recorded. The client thought that it was a confidential communication with his lawyer, but in fact it was a recorded conversation with his lover. The lawyer had also lied to the Department for the Correctional Services to obtain legal visiting rights for the ulterior purpose of furthering the personal relationship as opposed to the legal relationship. And so the court ultimately held that this lawyer was unfit to practice law and removed her name from the role. Where the intimate relationship is not impacted upon the quality of representation or generated improper conduct, it's unlikely to generate striking off or suspension, but it's still frowned upon. In one of the incidents actually in Morel, Miss Morel was taped by prison authorities in a non-legal phone call with one of the prisoners. She appeared to laugh when he said to her, I talked another prisoner into cutting his throat. And this really impacted on her good fame and character as well. So yeah, Morel's an interesting case, and it's really worth having a good look at that. Again, Del Pont covers it in some detail. The last thing that I want to talk about before I finish this recording is also the extent to which there can be a conflict or what our duty of loyalty is when we have a client who has special needs. You'll find some materials on Canvas about interviewing clients with special needs, and I would strongly advise you to take a look at that material and to consider what that means. It is really important to understand the circumstances in which the way that you deal with clients needs to change depending on who those clients are and what their particular needs are. And we're seeing over time that our understanding of what it means for a client to suffer a disability, to use the words that are in the cases, is getting broader and broader. And this is also following the trends that we're seeing in the Australian consumer law. So we're seeing where there is the potential for someone to misunderstand a situation, and the lawyer is in the position where there is that information asymmetry, that moral hazard that we've come back to over and over again, being really confident that your client understands. Now, this can happen even in corporate transaction law. One of the things that many corporate lawyers get very skilled at doing is finding ways to talk to their clients so that the client doesn't, client may not actually want to tell you that they don't understand something, or that they don't understand or appreciate the breadth of the way that the law works. They can be quite embarrassed, I guess, that as senior commercial people, that they find a particular aspect of the tax law complex, or that they haven't been involved in an M&A transaction that involves a particular type of subcategory, a Russian roulette clause or a competition issue or something like that. And so finding ways to communicate with your clients, finding ways to talk to them so that you can be comfortable that they are listening to you and that they understand your advice is really important, whether they're clients suffering an intellectual disability, an issue with language, or an issue with ego. I see it as the same kind of question across the gamut. So again, read those materials that are on Canvas, and make sure you have a look at the link to the National Pro Bono organisation and see what that says as well. And that'll put you in good stead for getting ready for the next video, where we'll deal very briefly with independence of your advice. Cheers.